All right, we're now recording. I'd like to thank everyone for coming to today's Wednesday webinar with the Mid-Atlantic Women in Agriculture. I'm Shannon Dill, and I'll be moderating this session. Today, we're going to be talking about agricultural labor mistakes to avoid. And you can see the list of webinars that will round out this year. So we offer these the second and fourth Wednesday of each month. Here in the blue link, extension.umd.edu/womeninag, are where all of our webinars upcoming as well as archives are located. We are recording this session and we'll be sending it out along with the slide set. We would like to give a big shout out to our sponsors of the Mid-Atlantic Women in Ag program as well as the collaborators in this program. And with that, I'm going to turn today's presentation over to Megan. She's worked with us on a number of programs, and I'll let her introduce herself, and I'm going to mute. Any questions that you have, please feel free to put those in the chat pod.
Great. Thank you, Shannon. Good afternoon, everyone. Thank you for registering for the talk today. Let me just set up my slides here so you can see. All right. So my name is Megan Todd. I am the research assistant and a lawyer at the Agricultural Law Education Initiative. Today I'm going to give a talk about the 5 most common mistakes for farm employers. This is going to be a general list, of course, and I've also included at the end a few things unique to this year due to changes in regulations made in response to the COVID-19 pandemic, of course, because we can't have any presentation this year without mentioning coronavirus, unfortunately. All right. So for anyone who doesn't know, ALEI is it's a University of Maryland system partnership brought together through the Empowering the State initiative. Our sole purpose is to provide legal resources and education for Maryland's agricultural community. Okay, and a standard lawyer disclaimer here. I just want everyone to know that nothing I say today is meant to be legal advice. This presentation is for educational purposes only. And then one more thing before we get started, a shameless little plug for our conference coming up in November. We do an annual conference, an agricultural and environmental law conference. This will be our 6th year hosting it, and this year, for obvious reasons, we're going to offer it online. It's been traditionally a place where we educate farmers, ag service providers, lawyers that represent agricultural clients, students, et cetera, on timely and relevant legal issues. Every year we work really hard to make sure the panelists that we have are experts in their field and the topics they're presenting on. This year we're going to be holding it 6 different webinars over the first 3 Mondays in November. They're all going to be free and recorded, so they'll be available after as well on our website. They'll be at 2 p.m. and 3 p.m. Running about 45 minutes, and we're also going to make sure we keep our traditional structure where we have time at the end for attendees to ask questions of the panelists. So register today. You can get more information at the link here. If you have questions on any of these topics, come ready with them. We're going to be happy to have that conversation online this year. A little bit of a preview of some of the topics that we're going to be presenting on this year include risk management during the pandemic, particularly from the perspective of Maryland's dairy farmers, but it should include tips that are useful for anybody, any type of producer. We're also going to have several on different water resource topics. So there's going to be one on WOTUS, on the Conowingo Bay settlement, and then also on the recently announced lawsuit announced with CBF against the EPA to enforce the Bay TMDLs. Because we all know that Maryland farmers work really hard to keep the water quality healthy, and we want to make sure that other states in the region are doing the same. So a little bit of information on the motivation behind that lawsuit. And then every year we also wrap up the conference with a panel or a presentation from our colleague Paul Gloringer discussing topics to keep an eye out for the coming year, and that's always a really big hit. So feel free to register. It's, like I said, it's free, nothing to lose, and you'll have access to some really great content. All right, so let's dive in. First on our list is interfering with at-will employment. So most states have at-will employment laws. That means that in the absence of an express contract, agreement, or policy, employees can be terminated or quit, either way, with or without cause and without any previous notice, as long as it's for a non-retaliatory or non-discriminatory reason. It also means that the employer can modify the terms or conditions of employment subject to the same restrictions, non-discriminatory, non-retaliatory. So, non-discriminatory means that you don't terminate someone based on a protected class according to the federal and state laws. So that, for example, could be the American with Disabilities Act, ADA, protecting people with disabilities, the Age Discrimination Act, you can't fire somebody for their age, and of course, race, national origin, religion, gender, things like that. The non-retaliatory aspect means you can't fire employees in retaliation for engaging in protected activities. So those are things like filing a workers' compensation claim or filing a lawsuit following injuries that they sustained on the job. Other things like missing work for jury duty, helping form a union, or for refusing to do hazardous work. So those are reasons that you cannot fire someone at an at-will employment situation. But if you can unintentionally, either through oral or written documents, negate this at-will employment presumption by agreeing to only terminate employees for cause, or only in accordance with established procedures, or by specifying a guaranteed duration of employment, and that may be done either in a job description, an employment contract, or an offer letter. It can also happen in handbooks. So handbooks are, they can create a for-cause firing requirement. It's great to have a handbook. They're great for outlining your workplace structure, and it's a great place to answer common questions that your employees might have. But, for example, if you include a section on terminations and you include, say, like a 3 strikes policy or some other process, then you are binding yourself to those promises to your employees. So if you don't follow those steps before terminating an employee, they can, basically fight back. Another place to watch out for what you write is in your job descriptions. If you have a position that requires the ability to do specific tasks like heavy lifting, operating heavy machinery, following written instructions, things like that, the advertisement should clearly state those essential job functions. It just protects you down the line in the case that you do need to terminate someone and you have a for-cause situation set up in a handbook or other place. Of course, the one exception to this at-will employment presumption is when you hire migrant workers. So the Migrant and Seasonal Agricultural Worker Protection Act, MISPA, for instance, requires that you use employment contracts with specific provisions when you hire migrant and seasonal workers, and the same thing for H-2A visa workers. So for those employees, you definitely need to have a contract and follow MISPA and the H-2A laws, but for any other employee, presumption is at-will employment. So if you don't want to interfere with that, you just have to keep an extra careful eye for what you write in these documents. All right, moving along. So number 2, let's click here. There we go. Number 2, neglecting the I-9 process. So what is this? Basically, it's a form that you have to fill out when you hire new workers, and its aim is to verify the identity and the status of workers. It requires the employer to physically examine those identifying documents within 3 days of hiring someone. You also have to maintain records that you had that form filled out and inspected those documents for usually a minimum of 3 years. So this is important because, there we go. This is important because, it's your form of defense against a potential claim of knowingly employing someone who's not authorized to work in the United States. And I know farmers actually have to do a mind-boggling amount of paperwork, and this is just another form that they have to fill out, and it can easily slip through the cracks. But it's really simple. It's something that you don't want to forget to do. You know, it might be you're in a rush to get workers out on the field or help out during the summer, but you definitely need to make sure you have this form filled out. Inspect those documents because they have to, in order to have a valid defense, you have to have copies that they reasonably appear genuine. You look at them and they have that person's name on them. They seem like they're authentic documents. Handwritten, for instance, things like that. And so if you have those records on hand, if you're audited or inspected, you're going to have that protection. So it's really simple. When you get the slide deck, the document here, this is a picture of the I-9 form. If you click on it, it should be hyperlinked to the most recent form of this document that you would want to use. There's also a hyperlink on this previous slide that you can access it and get some more information. It's a blog post that we put together on how to fill it out and making sure you comply with the federal requirements of that. Okay, moving along. Number 3. And I'll make sure I'll take some pauses. I'll try to keep an eye out for those questions in the chat box if anybody has them. All right, so number 3 is pay minimum wage and overtime. This might be the most hefty of the list today. We all know that you have to understand and apply those ag labor exemptions correctly. It's pretty crucial that you make sure you pay your employees what they are legally entitled to. So first of all, we know the federal minimum wage sets the floor of what the minimum wage is. Currently, it's $7.25 an hour. It hasn't changed since 2009. But if states and localities can set higher minimum wages if they want. I've listed the rates, the current rates as of yesterday for the Delmarva region. And so you can see that a lot of times they are higher than the federal minimum wage. There's some asterisks by Maryland, Pennsylvania, and Virginia. These are states that you want to definitely keep an eye out for because Maryland has a statute that is going to be increasing annually. So you want to make sure you check every single year that you know what the correct state minimum wage is. Pennsylvania, there's been some push for increasing the minimum wage recently. Nothing has gone through, but you never know. Next year might be the year. And then in Virginia, it's set to go up to $9 an hour next year. So, but not this year. So just keep those in mind. Double check what your state's rates are, and also the county or municipality area that you live in, because those could be even higher or different than your state's wage. So there's that. But then, like I said, we all know that there's ag employees are often exempted from these minimum wage requirements. And understanding when and how these exemptions apply is crucial. It just might be tricky depending upon your individual operation. And also just remember that workers on for-profit farms cannot waive their right to be paid minimum wage. You can't have volunteer workers, doing your work for you. So first, we'll talk about the different types of employees that are usually exempt from minimum wage requirements. These are all, just for your knowledge, these are all laid out in the Federal Labor Standards Act. So these are federal standards. States might have some variation that I'll talk about in a little bit too. So first of all, these are the first types. Anybody that's your immediate family member is exempt from minimum wage requirements. And by immediate family members, I mean your children, your stepchildren, your parents, or your spouses. That's it. Not your cousins or your uncles or your nieces and nephews. It's just your immediate family members are exempt from minimum wage requirements. Next, we have those that are principally engaged on the range and the production of livestock. And then hand harvest laborers who commute daily from their permanent residence, paid on a piece rate basis in traditionally piece-rated occupations, and they work for fewer than 13 weeks during the preceding calendar year, so basically seasonal workers. And then minors who are under 17 and in the same boat who are seasonal workers, and they work on the same farm as their parent, and they are paid the same rate as those who are over 17. So these types of employees are exempt from the minimum wage requirements. States might also have additional types of employees that are exempt from minimum wage. So for example, in Maryland, anybody in Maryland who is engaged in the canning, freezing, packing, or processing of perishable or seasonal fruits and veggies or other commodities is exempt from the state minimum wage. However, you got to keep an eye out for those too, because even though they're those types of workers that are beyond this federal scope are exempt from state minimum wage, they are still subject to the federal minimum wage. So it can be really tricky. You have to keep an eye on what your employees are doing and which wage applies. And additionally, for different groups, under 18 or under 20, it depends on what age they might be exempt from minimum wage requirements too, regardless of what duties they have. So keep an eye out in your state laws for what age you have to start paying minimum wage. Another exemption to keep in mind for agricultural operations is the 500 man-day exemption. This is really to benefit the smaller scale farm operations, allowing them to pay less than minimum wage if they satisfy this equation, which is if you, and during any quarter of the previous year, you use no more than 500 man-day hours for that quarter, for any quarter. This is often also adopted by states. So the workers would be exempt from the state minimum wage requirements too if a state adopts it. And this is true in Maryland, but just make sure you check your state's laws to make sure. So for example, we have a little equation here in the corner. If you have, one full-time worker for the whole year, he works 6 days a week, that's going to be about 300 man days, and you would be exempt from the minimum wage. However, if you say during the summer you bring on 7 full-time workers who work 7 days a week, for that quarter you're going to have 546 man days. And that will put you over, and unless the other exemption applies, you're going to have to pay them minimum wage, your workers' minimum wage. So like I said, it could be tricky. Just a lot to keep an eye out for. There's a link here at the bottom of this equation box to a document on the ALEI website that it tries to explain a bunch of different labor laws that apply and also gives some more detail on the 500 man day rule exemption for anybody who wants some further reading on this. And I would just say, just be sure that if you want to use this exemption, just be careful to document the days and the hours that your employees work, just to ensure that you are keeping within that 500 man day exemption block. And you have to also make sure that the work that these employees are performing falls into the definition of primary or secondary agricultural labor, and this is defined in the Federal Labor Standards Act. So here we're going to go into that a little bit more detail. So the type of work that allows you to pay less than a minimum wage is either primary agricultural work or secondary agricultural work. You really need to examine this closely and pay really careful attention so that you can avoid underpayment of wages. So primary ag work is, things like traditional farming, planting, maintaining, and harvesting the crops, in addition to raising animals on the farm. And then secondary agricultural work is stuff that's done incidental or in conjunction to those primary operation agricultural work. And so that can mean including preparing products for market, delivering your products to a storage facility or to a market, or to the carriers for transportation to a market. Not on this list is things like working at a farm stand, selling produce at a farmer's market, things like that. So you're going to have to be really careful if you have workers that perform both, the farm work and the packing and also selling the produce to your customers, because If you have an employee that in the same work week performs work that is exempt, so it fits into this agricultural work description, and work that is not exempt or covered, but still covered by the Federal Labor Standards Act, then that employee is not exempt for the entire week, and the minimum wage and overtime requirements do apply. So they would be entitled to minimum wage and overtime. So I know it's really fuzzy, it can be a little confusing, but you have to pay really careful attention to the hours that your employees are working, what duties that they are performing, and double checking that they are in line with this definition or not in line with the definition, so you can have a better idea of what employees are entitled to what wage. And then for ag overtime, for employees that work over 40 hours a week, the Federal Labor Standards Act exempts all employees that are exempt from minimum wage from receiving overtime pay as well. So if you keep track of all that information, you'll know that they're also exempt from receiving overtime pay. An exemption, you also of course have to keep track of what your state law says. So for example, in Maryland, farmers in Maryland who have operations that are not exempt from minimum wage, they have to pay overtime only after 60 hours per week for anybody that works on the farm. So it's a little bit different than the 40 hours per week, but that's only for employees that are not exempt from minimum wage and overtime, as discussed above. So like I said, it can be a little tricky. According to the Department of Labor, this is definitely one of the more common employer mistakes, is to fail to pay overtime to employees whose jobs are related to agriculture but do not meet the Federal Labor Standards definition of agriculture. Yes, I know it can be tricky. If you have questions, we do have resources on our website, and we are always happy to answer questions if you reach out to us. Our contact information is at the end. It's a lot to keep track of. Okay, so moving on. Number 4, misclassifying independent contractors. So why is this a common mistake? Well, employers have significantly fewer obligations when they engage independent contractors, so it can be tempting to call a worker an independent contractor. However, failing to properly classify a worker as an independent contractor or as an employee versus an independent contractor can definitely have steep financial consequences. Usually it's because when you have an independent contractor, your labor costs are reduced. You don't have to pay them unemployment insurance taxes, other payroll taxes. You don't have to pay workers' compensation insurance premiums or other benefits. So if you unintentionally classify somebody and then it's found out through an audit or an inspection, you're going to have to pay all of those taxes and fees, usually in a much quicker time frame than you otherwise would have to do. So for anybody that's curious, I included a link here on workers' compensation coverage, when it's required for employees versus for agricultural operations and when it's not, just if you are interested in that topic. So how do you know if you've misclassified a worker? If it's unintentional, you don't want to do it on purpose. You have to be really careful that when you hire somebody, that you pay attention, like I said, to what their duties are and how much control you have over that person's performance. So it's been judicially defined. An independent contractor is somebody who contracts to perform a certain work for another person according to their own means and methods. And they're free from the control of the employer in how they actually accomplish the final product or work result. Even if you have a contract or a signed agreement that declares that this person is an independent contractor and they agree to it, that is not enough by itself to prove that an employer-employee relationship did not exist or does not exist. Instead, a court or Department of Labor, they're going to predominantly consider the level of behavioral or financial control that the employer maintains over that worker. So we have here the ABC test. It's to help you, ask yourself whether or not a worker is an independent contractor or, in fact, an employee. First, you ask, is the individual, is this person free from your direction and control? Do they have a little bit of freedom to determine how they're going to accomplish what you hired them to do? Second, is this individual customarily engaged in this type of business? So do they do the same work for other people as well, or is it just for you? And then finally, you can ask, is the work outside of your usual course of business or done at a different place than your usual place of business? And if you answer yes to these three questions, then more likely than not, you have an independent contractor. So I put a link in here in the slide for you to access later. It's a link to the IRS guidance page that goes into a little bit more detail on how you can determine if a worker is an employee or an independent contractor. It gives more detail on the types of behavioral and financial control that the IRS keeps an eye out for. Things like paying hourly or hourly rate is for an employee versus just a one lump sum for the completion of a project. It's typically how you'd pay an independent contractor. Things like that, whether or not they use their own tools or whether they are using your tools and equipment. And like I said, whether or not they work only for you, like an employee might, or whether they do the same type of work for other people as well, and they aren't bound or reliant on you for their financial well-being. So if you want more guidance on that, definitely check out that link from the IRS to help you keep track of where that line is between independent contractor and employee to make sure that you can save yourself some heartache or fines down the line. Okay, and now we're on to the last common labor mistake. And this has to do with improperly employing minors. So long as labor is done outside of school hours and is non-hazardous, most state laws for employment of minors do not cover farm work that is performed on a farm and are working for a parent. So your kids basically can work on your farm, and the government trusts you to keep their well-being in mind and not work them too hard. But if you happen to hire neighborhood kids or your nieces and nephews for the summer to help out, then you're going to need to make sure that you're following the federal and state laws for the employment of minors. So, whether it's on a full-time or a part-time basis as employees, or if you bring on interns or apprentices who also have their own unique set of standards and laws that apply to them, but you have to keep track of their ages. And that's for the purpose that you know what minimum wage to hire them at, what to pay them, what their hours are, when they're working, and what type of duties that you assign to them. So I'm going to go over just the typical federal standards in these next few slides for age groups, but I found a really useful table on the Department of Labor website. I've given the link here, and that is really handy. It gives a table of which states have adopted the federal standards and which states have additional standards that you have to keep an eye out for. So it goes over just the basic child labor standards, and then it has a table at the bottom for different hazardous activities that are permitted by state. So that's a really helpful tool. I highly suggest if you employ minors in any form that you go check out that table just to double check what your state may require in addition to the federal standards. But most states have adopted the federal standards in some form. So, like I said, minors that work in agriculture on a farm that's owned or operated by their parent are exempt from the federal ag child labor provisions. Like I said, they trust you to take care of your children. But minors who are not your children or the children of the farmer, you have to employ them subject to the federal child labor provisions. And those are broken out by different ages, like the age of the minor have different requirements. They're mostly the same, but they differ a little bit. So we'll start out with children that are 10 or 11, not under, but children aged 10 or 11 may be employed if you really need them to hand harvest on a short seasonal crops outside of school hours only, and only with a special waiver granted by the Department of Labor. So if you really need to hire that 10 or 11-year-old, you're going to have to go through a few extra hoops and get that special waiver. But it can only be done outside of school hours and for hand harvesting short season purposes. The next age group we have is children that are under 12. They can be employed outside of school hours, would be the common theme, with non-hazardous job duties on farms that are not subject to the Fair Labor Standards Act minimum wage, so long as their parents are also employed on that farm and have given consent. Okay, so you have to just make sure that you employ the parent. The parent consents. You're not subject to minimum wage standards, and you keep their hours limited to outside of school and non-hazardous duties. Really similar for minors that are age 12 or 13, outside of school hours, non-hazardous jobs, but only on a farm in which their parent works or with the written consent of the parent to do those work during those hours. Once a worker reaches the age of 14 or 15, there's a little bit more flexibility. They are still outside of school hours, of course. They can perform any non-hazardous job, and then some states allow with certain training or certifications or with adult supervision, they may perform certain hazardous duties. And I'll go over in the next slide what I mean by hazardous duties. Okay, and then once the minor or the worker reaches the age of 16, they're no longer subject to the child labor provisions, meaning that they can work outside of school hours. They can work during school hours. They have more flexibility, and there's less restrictions on the duties that they can perform. Like I said, you're going to have to double check your state laws to see if they have imposed a higher age limit on the restriction of hours or hazardous duties that they are able to perform, but for the most part, if they've adopted the federal standards, there's fewer restrictions once the worker is age 16. Okay, so what do I mean by hazardous duties? Here's a really basic list. So basically, operating any heavy machinery or assisting to operate any heavy machinery. So that includes corn pickers or grain combines, chainsaws, things like that. Operating tractors that are over 20 PTO horsepower is included. Working inside a silo or a manure pit. Handling or applying certain agricultural chemicals like pesticides, basically. And then working in, stalls or yards close to stud animals or a sow suckling pigs. So for any of these job duties, you can't assign a minor under 16 generally to do this work. Like I said, some states might exempt 14-year-olds if they have proper supervision or certification or training. You just have to double check your state law. So I would definitely follow that link that I provided a few slides ago to look at that table and make sure that if you have minor employees that you keep track of what you're asking them to do. Okay, so that wraps up the top 5, the general list of the most common mistakes. Those are things that are just easy to overlook if you have an operation, it's high season and you need to get stuff done and stuff rolling. Those are things that if you're in a rush, it can be easy to overlook or forget to document. Like I said, I know there's a lot of paperwork, but it's important to keep those things in mind. So I'm going to go over just quickly, not in much detail, but I'm going to bring these up for you so that you know about them in case you haven't heard yet. Some changes that are in place just for 2020 due to the COVID-19 pandemic. The first is the Families First Act, Coronavirus Response Act. So this requires farm employers to provide paid leave to employees, which is different than the norm for agricultural operations. And this is done through two different provisions. There's the Emergency Paid Sick Leave Act and then the Emergency Family Medical Leave Expansion Act. So in a really small nutshell, Emergency Paid Sick Leave Act, you have to pay sick leave to employees who take leave due to if they have symptoms of COVID-19, if they are sick with COVID-19, paid sick leave. They are entitled to that, and there are certain restrictions on what they're entitled to receive in terms of amount and for duration. And I've included a link at the top here, the sick and family leave. That's a link to the actual law, like the text of the law for you to read if you're interested in that. And then further down, there's the paid sick leave. There's a video, a webinar just like this, and then also a weblog, an article that goes into more detail about what those different limitations are for the paid sick leave, if you're interested in knowing more about that. There are, of course, still exemptions for specific sized employers that are written into the law. But generally, it's definitely, for this year, it's reduced the number of employees that employer has to have before reaching that exemption. And then the Emergency Family Medical Leave Expansion Act covers, if a worker has a family member that is sick with COVID, or their kids are out of school due to the pandemic and they need to take time off of work to take care of them, then that's also covered with certain limitations as well. And those are covered in the resources that I've linked to here on the slide for you. One good thing is that if you do have to pay these sick leave to employees, that you can qualify for payroll tax credits. And this link here will give you some more information about that and how you can make sure you get those if you are paying sick leave to employees this year. I will mention that this is only for 2020, so this expires as of now. It's only meant to extend until December 31st, 2019 or 2020, and we'll see what happens in January. But for now, this is just for this year. And then lastly, I'm sure many producers are aware, especially if you're in ag tourism, that there are CDC and local health department guidance requiring you, if you're going to open it back up for business, they require you to follow social distancing practices. You're going to have to train your workers in the proper way to use personal protective equipment. You're going to train them on how to properly hand wash and how to report and identify symptoms of COVID-19 in both themselves, their workers, and in the customers that are coming through the business on a daily basis. You're also going to have to make sure you take steps in your operation. This is more relevant if you're having members of the public come onto your property, but having visual cues to help them socially distance when they're on your property. Make sure you have a policy and procedure in place for each aspect of your operation, how to make sure that your employees are socially distancing, your customers are socially distancing, and how are you going to enforce them. So that's a big part of this year. We are hearing about some people, having fines for failing to enforce these. We've definitely heard about some complaints about some farms not having their workers at farmers markets or roadside stands wearing masks. That is something that customers are looking out for and concerned about. So if you haven't heard about this, or if you want some more resources on how you can get these things done, there's plenty of resources out there. We have a link here to the ALEI website, and this is our sort of repository for all the COVID-19 related resources that we've put together. And on that page, we have links to our blog articles. We have links to MDA and CDC releases, guidance documents. And for just a quick checklist, I've included this link here from the MDA on the Agricultural Safe Business Practices, Face Covering, and Social Distancing Compliance Checklist. It's a pretty short, condensed document to help you just get an overview of what you have to do. And if you need more specific industry guidance, like if you have an ag tourism operation or pick your own operation or attending farmers markets, things like that. There are also specific guidance documents related to those activities on our LEI website that's linked here. So those are the big things, the top labor mistakes to keep an eye out for, to avoid. Here is just a summary slide for you. If it was a lot to take in, it's a lot. It's definitely a lot. But here's just a summary slide for you to make sort of like a checklist, a one-page thing for you to look at. And with that, I would say thank you so much for attending today, for listening and going through this list with me. If you have any questions, and feel free to ask them in the chat. But if you don't want to ask them now or you're listening to this recording later, feel free to contact us by email. You can contact me personally at motodd@law.umaryland.edu, or you can contact the ALEI team, and we can just all get the email, and whoever feels most qualified to answer your question will get back to you at umaglaw@umd.edu. If you prefer to do a phone call, you can always call us at this number and leave a voicemail, and somebody will get back to you as soon as we can.
Thanks so much, Megan. Really appreciate it. We do have a couple questions here in the chat pod. Let's see. The first one is, let's see. The first one is, although for nonprofit operations aren't supposed to have volunteers, it happens routinely on very small farms. How would you recommend a farmer properly classify and address volunteer status?
Oh, that's a tricky question. Is for nonprofit operations, yeah, it's pretty common. If you are a for-profit operation with volunteer workers, well, that's a tough question. I'm going to ask you to, can you email me your question? Because it might take a little bit more research on my part in a little bit more detail on what your operation is and how those volunteers are working for you, like how many hours and what duties they're performing, just so I can give you the most accurate information. I don't want to say anything wrong for anybody, but that's a really interesting question. I just know generally the rule is if you have a worker and it's sort of on a regular basis, they cannot waive their right to be paid minimum wage. But if they're sort of like a sporadic thing, just send me your question and I will do some research for you. Yeah.
All right. And so the comment additionally was, especially for like urban farms where you might actually lose productivity or efficiency by having volunteers, but make up for it in the general goodwill or interest of the agriculture community. So, the management time, or maybe volunteers doing maybe a practice incorrectly could create some time or inefficiencies, but it's generating goodwill and interest.
Okay. I mean, is that for the same question?
Yeah, I think it's kind of related to the same question, yes.
Yeah, I would say just still email it to me. I mean, if you do that, you kind of open yourself up to some liability issues also. So I'd be interested to hear more about it. And like I said, I want to give you some accurate response. So I'll have to look into it a little bit more. But I definitely understand where you're coming from about wanting to save resources and build a relationship with the community and have them come on and participate in your operation and understand what you're doing. Just making sure that we do it in a way that prevents liability on your part is what we want to do.
So. Other questions? There's a chat pod here and a Q&A if you have questions for Megan.
I see a question here. What is PTO horsepower? That is just I'm not a mechanic, but that's just something that has to do with the power of the tractor. As it stands for power take-off shaft. It's just related to how powerful your tractor is.
Okay. Other questions for Megan? Well, Megan, we always appreciate the agricultural law topics that you guys provide. Very good information. We will be sharing this recording as well as her slides. So if you registered for the event, you'll get a link within the next day or so. And of course, there's Megan's email if you want to get in touch with her. All right. Thank you, everyone. Thank you, Megan.
Thank you, Shannon. Have a great day.
You do too.